much for coming. So let me quickly introduce the panelists, although each of them deserves a long introduction, but in the interest of time, I'm going to make a brief introduction and then we'll pass it on for thought sharing and an interactive discussion. So first, the first panelist is Honourable Mr. Justice David Locke. He is a judge of the Court of the First Instance of High Court. He was in private practice before he joined the Hong Kong judiciary in 1995. He was appointed as district judge in 2001 and judge of the Court of First Instance of the High Court in 2015. He was responsible for the setting up the intellectual property list in the High Court, and he is now the judge in charge of the list. I always call him the boss of Hong Kong IP judiciary. And our second panelist is Ms. Winnie Yeung. She is the chief legal counsel of Microsoft. She is responsible for all the legal matter and public policy matters for Greater China region at Microsoft. Before Ms. Yeung joined Microsoft, she was with the law firm Baker McKenzie in Hong Kong, specializing in IT licensing, intellectual property rights, and privacy protection. She is credited as the solicitor in Hong Kong and England and Wales. Ms. Yeung is an HKU graduate, as I just mentioned, and she also holds an MBA from the University of Toronto. Our third panelist is Professor Wang Qian. He is a professor at East China University of Political Science and Law, a renowned scholar in Chinese copyright law. He has published more than 100 papers and commentaries. It seems that, in my knowledge, no one in China has published more papers on copyright than Wang has done. He's absolutely a celebrity type of law professor in China. So he has been appointed as an IP expert advisor by various government agencies and courts. And he is also a member of the editorial board of Journal of Copyright Society of USA. I'm also a board member of that journal. Great that we are also colleagues. And he has been recognized as the most influential figure in IP protection in China and the outstanding contributor for China copyright protection. Last but not least, Ms. Ling Ho, our fourth panelist, is a partner at Clifford Chance. She has spent over 30 years advising clients on intellectual property related matters in Greater China region. Her expertise covers the full spread of contentious and non-contentious IP issues. She is the head of Hong Kong litigation and dispute resolution practice group at Clifford Chance, as a core member of the firm's global tech group with particular focus on IP, cyber, AI tech disputes, and risk management. Ling has extensive trial, deal, and strategic consulting experience and has acted in leading cases in the fields of trademarks, patents, and copyright designs to confidential information. So without further ado, let me turn it over to Ling to really move ahead and bring us another piece of thoughts.
Okay. So good morning, everyone. I think a few years ago, there was very little public awareness about the interplay between AI and IP. Much of the attention was really on the regulatory aspects of AI development and use, like bias, transparency, and data privacy. But then with the more widespread use and also availability of generative AI, the public awareness that there is also important legal considerations became higher. And when we talk about legal considerations and also in the field of generative AI, which is what we are going to talk about today, and where these issues are most acute, we are really thinking about those issues that are being debated litigated and also under considerations. And these are issues relating to infringement and right of use. Also, uncertainty around ownership of AI-generated work. And also questions about unlicensed content in training data. And also the question whether or not authors are able to prompt AI tools by direct reference to copyrighted and trademarked work with name, mentioning name, but without permission. And all these issues are still being debated, are still under consideration, notwithstanding the lapse of time. And it's not surprising that lawmakers and policymakers are having difficulties to keep up, because existing laws were written without these technologies in mind. And the laws are having difficulties to catch up with the technological advancement. And particularly policymakers have the difficulty to balance the interest of all parties. So on one hand, they have to ensure, or they wanted to make sure that their territories are not less attractive to AI companies, and that they do not stifle by implementing laws, AI technology advancement. But on the other hand, they need to think about creators' interest. They need to make sure that creators' efforts are adequately compensated. So these issues are not straightforward, and need to be looked at from different perspectives. And I think that Professor Sun has today lined up a fascinating panel. Our panelists will cover important aspects of AI and IP from different perspectives. So Judge Locke will give us his insight from a law enforcement perspective, and also the difficulties that the courts face when having to educate on these new issues. Winnie from Microsoft will give us share her insight, or share how Microsoft is actually looking at these issues and in this very unharmonized environment. Professor Wang, we can't talk about AI without mentioning China. And so Professor Wang is going to give us a perspective from China and the country's approach to these issues. Now, before we go into the specific issues and questions, I want to ask each of the panelists a general question first. And may I start with you first, Judge Locke. We have heard this morning about how important the courts are. And the courts are now being asked to sort out, really, how the laws in the books should be applied. As we heard this morning, IP being territorial in nature, borderless technologies, we have all these unharmonized approaches in different countries. So can you tell us a bit more about the difficulties that the courts face and how it should be dealt with?
Yes, thank you. Professor Sun, ladies and gentlemen, it's good to be back. I still saw my photographs downstairs, so Hong Kong is my home. And certainly a great honor and pleasure for me to attend this AI seminar as a panelist. While the focus these days is always what the AI can do for us, there's a tendency to overlook the legal issues and the implications arising out of the use of AI. And perhaps today's AI seminar is a reminder to us about the importance of these issues. Now, first, before I answer these questions, I must put forward some caveats. Now, I'm not an expert in the use of AI. Neither do I know how AI works. I do not know how distillation works. I do not know how the interaction between different neural networks work. I think most of us here do not. That is why we have to have such kind of conference, so that people from different disciplines can come together and share the views as to how to tackle the challenges ahead. Now, secondly, I have to make clear that all these novel issues have yet been tested and argued in the Hong Kong courts. So whatever view I express today is only my personal preliminary view without the benefit of that detailed legal arguments. And so don't quote me if you have to argue a case in the court. Now, in the talk I've given in the Law Week in November, I have outlined 5 areas that perhaps need serious consideration or perhaps regulations. The first area is, of course, how to govern AI to make it more transparent and accountable. The second issue is how to avoid bias and discrimination in the use of AI. The third area is, of course, how to protect confidentiality and personal data in the use of AI. The fourth issue is product liability arising out of the use of AI. That is, you imagine a lot of automated driving nowadays. There's an accident, who are the one to sue. And the last area is of course, the IP issues relating to the use of AI. Now, the panel this morning will focus on the last issue, that means the IP-related issues. But we should not overlook the importance of the other issues as well. Now, in the absence of specific legislation, the courts all over the world are struggling to deal with all the IP issues related to the use of AI. I will roughly group all these issues into roughly 3 categories. The first category is focused on the AI program itself. Whether the AI program is a subject of protection, subject to some sort of IP protection, whether as a patentable as a patent, whether it's amount to a what we call now computer implemented invention. So whether it will attract copyright protections or whether it's protected as a trade secret. So now with the DeepSeek incident, this becomes the spotlight again. Whether the AI program itself is subject to certain IP protection. The second category is what I would call upstream issues. That is before the actual use of the AI. What we are talking about here is about the training data. That means we have a lot of copyright materials used to train the AI. So with this, if the use of this AI in the training materials, in the training of the AI, would that amount to copyright infringement? So that is what we call the upstream issues. The third category is what I call the downstream issues. That is, we are focusing on the AI-generated products. Whether these products will attract patent protection, whether it's subject to copyright protection or any kind of IP protection, or whether these AI-generated materials, if they are substantially similar to some kind of copyright materials, whether it would amount to copyright infringement. Now, as mentioned by Ling, there are confusion now in this area of the law, as the court in different jurisdictions are trying to answer this question. And most of these litigation are actually now still in the pre-trial stage, litigation stage. Even if there's a first instance judgment, they may be subject to appeal in the future. So confusion is hardly surprising. Now, our existing law were written in the pre-AI era. So the IP law are enacted. What is the aim of the IP law? Is to reward human inventor for the time, skill and labor and financial resources for the invention they make, or human author, an emphasis, human inventor and human authors, for using the skill and labor in creating new art pieces, writing music. The law are also made on the premise that the IP law will encourage or provide incentive for creating new invention or new artistic work for the benefit of mankind. Then, how do we apply these concepts to AI-generated materials? Was there any novelty, originality, or creativity with the material produced? Who was responsible for any novelty, creativity, or originality with the materials concerned? Was it the AI machine, the AI program, or the users, Now, AI users can just put in a few simple prompts and obtain a AI-generated products. You can just issue a prompt, ask AI to draw a painting which resembles the style of Rembrandt. So should the AI user have IP protections because the input that he or she makes is rather minimal? So this is quite different from the days when computer is only used as a tool, such as Microsoft Word, and the human author is very much responsible or for the creation of the final works. In the AI era, the causal link between the author and the creativity of the work is quite clear. Whereas for AI-generated work, such causal link may not be so clear. Now, one thing I agree with this morning, judges are poorly trained by a professor. That's true. Judges are poorly trained to answer these questions because that involves a lot of policy considerations. In my opinion, the interests of different stakeholders, such as AI developers, users, and copyright owners, should be fully considered in answering these questions. And answers should be provided in written laws and legislation rather than by way of court judgments. Otherwise, I'm afraid that confusion will continue to follow, and as different judges would have different views on these issues. More importantly, judges who usually know very little about the use and the operation of AI may not be aware of the full implications of the decision he or she makes. And the result, it may cause adverse effect on the development and the operation of AI ecosystem. Now, apart from this multidisciplinary perspective, which that is, one should consider the interests of all the stakeholders, I think there's also a multi-jurisdiction perspective. I think we touched on this slightly this morning. So if there are differences in the law in different jurisdictions, imagine one country adopt a very wide data mining exception, and another country adopting a narrow exemption. What will be the effect? The effect will be driving all the AI developers to the countries which have the widest data mining exception. So that is why a lot of advocates or a lot of academics are now advocating for harmonization of the law in relation to AI. This is certainly desirable, but I'm rather pessimistic about this initiative because AI legislation involves a lot of policy consideration, and nowadays even political consideration. So taking into account the geopolitical tension and geopolitical competition, I doubt whether any significant progress will be made in this area. Indeed, I see a tendency for some governments in the world to adopt a more cautious and, in fact, wait-and-see attitude to see the development of the law in this area. So I'm rather pessimistic in the sense that I think the lawmaking process will be rather slow in this area. So in the absence of harmonized legislation, or indeed any legislation at all, I'm afraid that the courts in different jurisdictions would have to struggle to deal with these AI issues in an ad hoc and piecemeal manner. And they will certainly cause confusion and uncertainty in the law. But while regulating AI and making new AI law a matter for the politician, I think what we can do today is to try to familiarize ourselves with these issues so that we can, in appropriate opportunity arises, that we can make contribution in shaping the law in this area. I also advocate for more interdisciplinary collaboration so that we can make well-informed decisions in regulating various issues arising from the use of AI. So I think that is my answer, that I think the confusion would continue to be there. As the professor has mentioned this morning, IP law may not be a good way of regulating because of the uncertainty with all the court judgments. And unless they are clear, of course, we judges, I think I attended the seminar about 1 or 2 years ago, organized by Professor Sun. We judges are not interested in questions. We are interested in answers because we are the ones who provide the answers. And then every time I attend this kind of conference, we have more questions than answers. I think, I mean, if you look at it, I think it's bound to continue, at least in the near future. Let's see how the law, I talked with the professor, let's see whether there can be some kind of movement in the United States, try to get the politician to understand the importance of legislating or regulating. Otherwise, if you leave it to the judges, I think rather hopeless. Yes, thank you.
That's very interesting, Judge Locke. So it seems the confusion will continue, but on the other hand, technology will not stop. It will continue to develop. So it would be interesting to hear how the commercial world is addressing these issues in this lack of clarity on these kind of issues. So Winnie, Microsoft being one of the leaders in AI development and provider of AI tools, how is it approaching all these uncertainties?
Yeah, thanks for that question, Ling. And thank you, Professor Sun, for inviting me back. It's a great honor to be addressing this audience today. And sorry. I'll let Grace work on that. So while we're working out on the slide, I just want to respond quickly to what Judge Locke was saying. Obviously, the professor and Judge Locke has also mentioned that, there's a lot of uncertainty and clarity about, what the legal environment is in regulating AI. But, the professor also says the technology is already there, people are using. And so, from a technology provider perspective, we try to adjust our course along the way. We obviously do not have all the answers, and we're also learning and listening to our users, listen to other stakeholders to help us and to work with the government in different countries to come up with the right approach in regulating this technology. So today, what I'm going to do is to share a little bit of, how we look at generative AI and what do we think of it when we look at it with copyright issues. And, last time when I was here, I was sharing with the audience about the responsible AI practices of Microsoft. And I think that also resonate well with what the professor said earlier today, is that, we are really learning in multifaceted manner, trying to make technology work in a human society. And, that involves many issues that we need to consider. And today we're just focusing on copyright and AI. So if you think about it, right, it's just a little bit over 2 years since OpenAI released ChatGPT. And boy, already, we're seeing so much potential and promises that generative AI is bringing. So we see that generative AI is enabling and leading to astounding and long-sorted breakthroughs in many different areas. I won't go through all these advances in technology or research that is listed on the slide. But if we just look at healthcare and life sciences, right, you can see that because of generative AI, it speed up the research and the work in coming up with cure for cancers, for infectious disease like COVID or HIV, or even neurodegenerative issues like Alzheimer's and Parkinson's disease. And we're only getting started, right? So before we dive into these questions today, I'd like to maybe just take a pause and take a look at what really is generative AI and how does it work. And also a health warning, I'm not an expert, I'm not an engineer. So, I'm also learning from my subject matter expertise colleagues and trying to share this information. So, generative AI at a very high level is really the sum of machine learning and artificial intelligence. It digests a huge volume of data to train a model so that it can perform different tasks. And it's generative in the sense that, it can create images, text, and other outputs from these data inputs. On this slide is a very high level description of how an AI model is being trained. And I would just flag 2 points. One, the training data that is being input into a model is tokenized. So the model only recognizes numbers and not text. Okay, so that's the first point to bear in mind. And secondly, once the model is created, it no longer needs to use the underlying data. Okay, it doesn't need the data, the training data to perform its tasks. But when we look at how generative AI is being so powerful, is because it has unlocked the access, is being unlocked by access to data. And as Judge Locke was mentioning earlier on the issue of potential bias, right? The more access the model has to data, it will improve or mitigate the potential of bias, and it will make the model more accurate and inclusive. And this is what, from a developer perspective, what we try to achieve. And so looking at, what generative AI is and what it is not, and which is relevant to what we are talking about today about copyright, I would emphasize that one, generative AI is not a copying machine. It does not copy existing data, but rather it helps to generate, to create new information. And secondly, it's not a database. The data is not required to perform tasks after the model is created. And the model itself does not contain data. It only contains the tokenized information. And thirdly, generative AI is a machine learning process to take knowledge and facts and make them more accessible and usable by everyone. So with that, let's take a look at the role of copyright in an AI-powered world. So as the speakers before me have mentioned, right, there's a lot of debate out there. There's a lot of uncertainty. So, how do we think about AI and copyright? So if we look back the history of copyright, right, it is the modern copyright law is really emerged with the advancement and introduction of the printing press in Renaissance Europe. So before printing press was introduced, books are very expensive and low circulation because it requires manual copying, right? But there is a low circulation of knowledge as well. So it's only, available to a small group of privileged elites. But with the printing press, the flow of information becomes much easier and it's more accessible by the public. And copyright law is created to protect the interests of rights holder. But even so, right, in the copyright law today, we still see exceptions and limits to ensure that the public has the right to use copyrighted works to advance knowledge and develop new technology and works. So in our view, these limits and exceptions serve many purposes, but specifically to support innovation and also to strike a balance between copyright protection and a reasonable use of work, which, Judge Locke and the professor has also alluded to. And in our view, a modern and flexible copyright system is essential. By providing clarity in legislation that the analysis of information and patterns from publicly accessible text and data is permitted, greater access to data is realized, and enable more organizations to innovate and achieve more. So with that, what is Microsoft's approach? As we were saying, we don't have clear law to follow, and so we could come to our own principles and approach, and hopefully we will adjust as we go along. So we follow 3 basic principles, and when we think about AI and copyright. First, AI tools and users must respect copyright. Second, the public has a right to use technology to develop knowledge from copyrighted works. And third, AI tools must benefit society broadly, not narrowly. So I think these sort of resonates with what Professor was saying earlier as well. And based on these principles, we have built a 3-pronged approach. The first approach is to advance copyright safety. And this is where we can use technology to mitigate the risk of near identical outputs. So technologies like meta prompts and filters, block lists, prompt transformation, content perseverance, provenance, and also from a contractual perspective, what we provide to our customers as we call the customer copyright commitment. And with limited time, I'll just show a quick example here. So for our users, if they go to Bing Copilot, right, and say, oh, I want to read the first chapter of a Harry Potter book, right? The tool is already set up in a way so that we would not infringe the copyright of the author and provide that chapter to him or her, right? But we would say that we'll provide you a summary and we'll encourage the user to go to the library to get a copy or buy a book, right? So this is how we avoid the user from infringing of copyright. The second approach is to empower rights holders to manage their participation with AI. So, we know that for some rights holders, they may want to have their information still available for users when they do a search, but they may not want the same data or same information to be crawled for training. So, we have made available tools for those rights holders. We respect their preferences and allow them to set up proper control for the webmasters. And we also, have a specific tools in our Microsoft Designer image creation tool to also honor respects from creators in a similar fashion. And last but not least, the third element of our approach is to really advocate for more open access to data. We firmly believe that, it's only with open access to data and available to, as many organizations as possible, that AI will continue to innovate. And, we support work with academia to explore the data commons for the AI era. So this is what I have to share this morning, and thank you for the opportunity.
So thank you, Winnie. As I mentioned, we cannot talk about AI without mentioning China. So Professor Wang, can I ask you, how is the Chinese government, or what is its approach and also attitude towards regulating AI development and use while still leading on the AI development front?
Thank you so much for the question. It's a very big question. We need a lot of days to talk about this in detail. But present, the most eye-catching thing from the circle of copyright from China is the judicial protection of the AI-generated content, or AIGC. So I would like to focus on that small point this time, and we can go back to the general policy issue later. Probably a lot of you know that in late 2023, the Beijing Internet Court held for the first time that the AI-generated content, which is image of a Chinese girl, should be protected as a work, and the copyright owner is the user. This judgment is highly controversial. Let's first review the facts of the case. The plaintiff, Wang, AI model named Stable Diffusion with the so-called model package specially designed for the Stable Diffusion to create Chinese-style girls. The first input the plaintiff to the AI model was dozens of the so-called positive prompts, meaning the elements he wanted to be present in the resulting image, such as a Japanese idol, the perfect face, dreamy dark eyes and long legs, and so on. A second input was so-called negative prompts, meaning that the elements he did not want to see in the resulting image, such as a disfigured body, the bad hand, the missing fingers. The last input was the parameters for the image. Then the plaintiff got the first image generated by the AI model. He was not impressed, so he modified some of the text prompts and parameters for 3 times. For each time of the modification, he got a new image. The issue in the case was whether the last image was a copyrightable work, and the court said yes. To briefly recap the points included in the judgment, the first is that the image is original one since it is not identical or substantially similar to any other images in the world. The second point is that the image is outcome of the user's intellectual input, and the AI model only serves as a tool for the user to create the image. The third point is that AI itself cannot be the copyright owner, but the plaintiff giving the text prompts should be recognized as the copyright owner. I think this judgment is deeply flawed. The judgment treats the AI model as a tool for the user to create the image. But it's not like a person pulling strings from behind the scene with the AI model only being the puppet of that person. It's not the case. A person might use tools to create works, including the physical tools such as pencil, camera, or computer board, programs such as Microsoft Word and Adobe Photoshop. But a tool will not be involved in the decision-making of the expressive elements of the resulting content. Tools are only passive means to implement faithfully the decision of the person to create a work. Let me show you an example. I made an experiment. I fed an English poem as text prompts to a text-to-image AI model named DALL-E, and I got this image. And then I fed the same text prompts to another text-to-image AI model named Midjourney. Make the comparison, we can find that the only thing shared by the 2 images is the theme of the sunset scene, right? Anything else is totally different. Why? Because the AI model is not like a pencil or camera. As the term generative AI indicates itself, an AI model can autonomously generate content based on its own algorithm and data training. The text prompts and other inputs of a user might impact the style, the theme, the topic, the subject of the resulting content, but they can't decide the expressive elements of the resulting content. So this example directly and strongly contradicts the main point of the judgment of Beijing Internet Court that the AI model is only a tool. It's not so simple. It's not like a camera or pencil. Actually, the person who's using the AI model can't even predict how the AI model is going to understand the text prompts, let alone to decide what content the AI model is going to produce. After the judgment of the Beijing Internet Court was published, a tech team did another experiment. It ran the same AI model, Stable Diffusion, with the same package model on 3 computers with different hardware settings, such as CPUs and GPUs, and the team fed exactly the same text prompts and parameters to the AI model. The outcome of the experiment even frightened the tech team because the same AI model on 3 computers based on exactly the same text prompts and parameters generated totally different images. How did this happen? I can't tell from the perspective of AI technology, but I think from the legal point of view, it's very clear. One act of creation cannot result in many different works, but one idea may lead to a lot of divergent works. The text prompts given by a user to an AI model, in my opinion, are very similar to the instructions of an art school teacher gives to art school students to make a painting. No matter how specific and how creative the instructions are, the paintings finished by art school students will always be dramatically different. And it will be ridiculous to allow the art school teacher to claim the copyright in the paintings finished by students, because the instructions given by art school teacher to the students are only unprotected ideas in relation to the resulting paintings finished by students in the idea and expression dichotomy. So are the text prompts given by a user to the AI model. They are only unprotected ideas in relation to the resulting content. That is why one set of the text prompts may lead to totally different images by different AI models, and even one AI model may generate different images on different computers. To conclude, I would like to show you a clip of my favorite US movie, Forrest Camp. Camp said that my mom, okay, if you can play that clip.
My mom always said, life was like a box of chocolates. You never know what you're going to get.
I think generative AI is just like the box of chocolates in the hands of Forrest Camp. No matter what text prompts you give to the AI model, you never know what you're going to get. That is why I think the judgment recognizing the compatibility of the AI generated content by the Beijing Internet Court is wrong. Thank you very much.